in different states, what happens is that the people who are, people are normally arraigned, in most cases at the magistrate courts, in some cases at the high court, but most of the cases go to the magistrate courts. Now, and that will be by the police. Even in capital offenses, the police will first go take you to the magistrate court and remand you in prison custody. Now, in many cases, the police will have no single evidence against you. At times, they just go to Oshodi and raid people standing by the roadside and take them to the police station. And the next day, they tell you, all of you should bring 10,000 for bail. Those who cannot bring the money for bail, they just type armed robbery. They just type one capital offense without any single proof of evidence, no knife, no gun, no weapon found on you. They just charge you to court out of wickedness that you did not bring money for bail. Now, when the magistrate sees armed robbery, the magistrates are primed to remove their hands. They are instructed. Once they see armed robbery, they say, no jurisdiction, remanded in prison custody. Now, the person will be in prison custody for 5 years, waiting for the DPP to make up his mind whether he has a case or not. Because once they remand you, they will now send your file to the DPP. In many cases, you will not even have the money to go and give the police to photocopy your file to take to the DPP. So the files will remain with the police for 1 year before it goes to the DPP. Remember, that person is in prison awaiting trial. How do you stop this? Give the magistrates the powers of the Attorney General of the states. At the point the charge is brought before the magistrate will have the power of preliminary inquiry. The magistrate will say, look, okay, you have charged this man with armed robbery. Can I see your proof of evidence? If there is no proof of evidence coming with that charge, the magistrate should grant bail on the spot. But if the magistrate sees some proof of evidence, the magistrate, okay, I remand you, awaiting trial at the high court. So in that cases, you can eliminate many of these cases of people who go to prison without any shred of evidence against them.
All right, just before you go.
And why would the attorney generals continue to possess the power, the judicial power, to determine whether you have a case to answer or not?
Let us stop that practice. Because in addition to that, let me jump in. Could you also explain, because you did some time ago, but lots of people didn't actually get the point, when you said that the commission does not necessarily have to wait for the attorney general to prosecute or go after certain persons, that a certain law had invalidated that position. Could you reiterate that, please?
Now, that is a different situation. What it means is that the powers to initiate a criminal trial is no longer the exclusive preserve of the Attorney General of the Federation or the Attorney General of the states. Any law enforcement agency can directly initiate a trial in court. And that was the case of Osahon against the Federal Republic of Nigeria, decided in 2006. That, of course, changed the whole landscape of the law. In fact, it was a full panel of the Supreme Court, and it was a split decision. It was 4 against 3. That was how narrow it was. 4 of them were of the opinion that you don't need the consent of the Attorney General. 3 of them were of the opinion that you need the consent of the Attorney General. So the majority took the day at the Supreme Court. And as it is now, you can initiate. Once you are a law enforcement agency, you can initiate without the consent of the Attorney General. But he has the powers to come in after you have initiated to say, look, I want to take over this case, either to discontinue or to continue it. This is also different from the case of the police, the situation where that I'm now enumerating, I'm explaining. The police can initiate too. In fact, the Supreme Court held in that case that the police can go directly to the High Court. So this practice of the police always going to the magistrate court with capital offenses is wrong. A police officer can go straight to the High Court and institute and file an information regarding a capital offense, not only a lawyer. Now, what I am saying is not really the powers to initiate this time, but the power of the magistrates, the jurisdiction of the magistrate to grant bail is different from this other instance you cited. I'm talking about giving powers to the magistrate to grant bail in capital offenses when there is no proof of evidence to support the capital offense. Now, the practice of also sending those files to the Attorney General for advice should be given to the magistrates. You know the reason? Because once the Attorney General sitting in his cozy office writes an opinion, and in some cases out of corruption, let us not hide the fact that a person who has clearly committed murder, an Attorney General will now write an opinion like a judgment of a court that you look at this case of so and so, the person, there's no sufficient evidence, I hereby decide that the person has no case to answer. That decision by the Attorney General is not appealable by those who are aggrieved. But if you give the power to the magistrate to decide, after preliminary inquiry, whether there is enough case, there's sufficient evidence to remand the person and refer him to the High Court for trial, that decision of the magistrate will be appealable because it will be a judicial decision given in court that will be subject to an appeal by those who are aggrieved by that decision.
All right, Mr.
That's the more reason why we must whittle down the powers of the Attorney Generals of the state to decide whether a person has a case to answer or not.